Good morning, everybody. Hello and welcome today to today's webinar broadcast. My name's Amanda Chadwick, and today we are talking about investigations in depth. I'm speaking on behalf of the CIPD HR Inform, and just a note to remind everybody that the detail contained within this webinar is based on Great Britain employment legislation, and clients in the jurisdictions of Northern Ireland, Republic of Ireland, Jersey, Guernsey and Isle of Man are asked to contact the advice service to obtain information relevant to your jurisdiction. So, happy morning to you, and to talk about investigations. The objectives are to gain practical advice on why disciplinary investigations are necessary, following the ACAS code of practice. And if you remember, 2003 was the year that we were rocked by doing a full investigation disciplinary appeal procedure. And in 2003, I remember the tribunals got together and said, we have been bombarded by tribunals. Actually, a lot of these cases we're hearing could have been sorted out in the workforce. The employer has got to do something about it. They've got to take control and manage the situation themselves. So in 2003, they made it the rules that you had to have a full investigation, a full disciplinary procedure, and give people the chance to appeal. And it was known as the statutory dispute resolution procedure. It's now known as the ACAS code. And I think at that point, 2003 was the year when people thought about getting contracts in place. You know, actually the law is 1972, you should have had contracts in place, but it became really the forefront of people's mind, business owners' minds, to get contracts in place in 2003 because they had to have written investigation, disciplinary and appeal procedures. So that's when I really saw a huge change in employment law then at that point. And we know since then there's been over 200 changes in employment law. It's very hard to keep up with. So the ACAS code, where does it go? Well, for me, it goes in the employment law handbook. As you'll hear on a lot of these sessions that I'm doing, is that myself and my sister are saying to employers, their managers, HR, there's been that many changes in employment law. Let's go back to basics. Let's make our handbook easier to understand, be comfortable with them. And I think because there has been so many changes in employment law, what we have is we've just added to, because we are very, very busy in our ordinary job. So we get very, very busy. We add new policies to the original handbook we've got, and we don't really know sometimes what to take out or what works and what doesn't. So let's go back to basics a bit. Part of this basic is the following a good investigation and following the ACAS code. So we'll talk about gathering information and creating a report, and the risks, obviously, of a bad investigation. So, oops, let's go back a bit, previous slide. Introduction. So you've received an allegation that a member of staff has acted inappropriately or breached company rules. So to handle this matter appropriately, an investigation will have to be conducted first. Only then can you decide whether there is a case to answer under the disciplinary procedure. So gone are those days of just jumping in and going, you've had it, you're dismissed. We have to do a proper investigation now to give people the chance to put their case across. So this is the first key stage. So the investigation will be the information that's relied on at all later stages of the disciplinary process. So that's from deciding whether there is a case to answer, the disciplinary hearing, and any subsequent appeal hearing. So once an allegation is received, this is all the information you have about the alleged incident. The investigation is the fact-finding part of the process. Without gathering all the facts and relevant information, how can an employer determine whether the employee is guilty or not on the balance of probability? So we have to do an investigation. And you know, it can look like somebody's guilty. We can feel like somebody's guilty. Our managers will tell us that somebody's guilty, but let's get the full facts in, make a decision. I've worked with people and attended tribunals and represented tribunals when they've typed up the results of the disciplinary investigation And what they've done, I remember one incident, this lady, they ended up in a tribunal. It was when they were doing an investigation, then holding a disciplinary, and then the outcome of the disciplinary. But what she was doing, she was getting all out of the way in one go. So she typed up the investigation letter, she typed up the disciplinary letter, and then the outcome of the disciplinary, she'd already typed it up. So she made the decision before she'd even had an investigation. And as a result, you can guess she sent the wrong letter out. So, you know, let's get this right. This is to give people their hearing and to do our due diligence. So that's why it's necessary to do this. So the necessity of disciplinary hearing, so investigations. So if we look at British Home Stores versus Birchall 1978, there's 3 steps that are required for a reasonable dismissal. The employer must genuinely believe that the employer committed the alleged offence. The belief must be based on reasonable grounds after an appropriate investigation, and the investigation must be reasonable in all the circumstances. So this is the landmark employment law case that outlined the necessity for investigations to take place. A full case report is available on our HR Inform. So for those clients of ours listening and that use HR Inform to write letters and help them through an investigation, this case is available for reference. But basically the facts are, there were irregularities identified in stock purchases at a British Home store. So to determine who was responsible for this, British Home Store took evidence from documents relating to purchases that staff had made, and also took witness statements. The evidence suggested that Birchall was responsible for the irregularities, and she was dismissed. Birchall argued that British Home Stores had not clearly established her guilt. The case set out the 3 steps required before dismissing an employee in order for it to be reasonable. If these 3 steps aren't present, then the dismissal will be unreasonable and a tribunal will deem this to be an unfair dismissal. An investigation is mentioned in 2 of the 3 steps, showing how crucial this is to the fairness of a dismissal. The practical way of looking at these steps is actually to take them backwards, i.e. have a reasonable investigation first to form a reasonable belief, and the reasonable belief in the fact that the employee committed the act of misconduct. So, internal disciplinary policy set out the process to be followed, and this will contain an investigation stage. Failing to investigate will therefore be a breach of company policy. So as well as case law saying that an investigation is needed, an internal disciplinary policy will say that the first stage in any disciplinary procedure is to have a full investigation. So if we look at a case that I was involved with, where a gentleman, I'll just give you a little bit of an overview. It's long-winded, but the gentleman involved said that it was in a fast food restaurant. The gentleman was a Thai gentleman. He worked extremely hard. He reported the machinery within the fast food environment that it was faulty. He'd reported it the day before in his shift. When he came into work the next day, early hours of the morning, the machine wasn't repaired. The food court worked in, the actual people had rang in sick, people had let him down, he was on his own. He was the manager, deputy manager of the store. He spent ages cleaning up the mess of the people the night before, who often did this to him because he was very, very hard working, kept his unit completely clean, and they knew they could just leave it for him to tidy up. So he found himself in a situation with lack of staff. He found himself in a situation where the unit was filthy. He found himself in a situation where the equipment wasn't repaired and was taking longer to heat up. And as a result of this, he couldn't open the store on time. His senior manager came in, who was under pressure, was irate, started shouting at him, pointing at him, putting up a tights in front of him, and just really not a very nice attitude at all. It was on CCTV. She insisted that he opened the unit because there was customers waiting. He said it was impossible to do because the fast food unit wasn't at the right temperature. It was against the law. She was raging with anger. She said, I'll be back in a minute. You better have opened up the store. Again, it was on CCTV. She then came back, demanded he open the store, and he said, I'm not putting my name next to temperature checking when the temperature is not going to be of the right temperature. And she said, if you don't open the store, you can get out. He said, I'm sorry, I'm not opening up when the temperature's not right. I reported the machinery the night before. Nobody's repaired it. As a result, it's taking ages. It's not warming up correctly. I'm not putting my name against the temperature check because we'll be serving food that might be undercooked. She's on the CCTV. She can be seen to point at him. She got his coat, threw it at him, and sent him packing. Now, he was adamant to have a full investigation, and throughout the conversation with his HR department, he said, please look at the CCTV. And he said, please, please, please look at the CCTV. You will see the way she spoke to me. You will see the way she conducted herself. You will see her throw the coat at him. And they had an investigation. And the HR department promised him that they would look sincerely at the CCTV, of which 1 hour later they hand delivered the investigation letter, the results of it, for a full disciplinary. And then even at the disciplinary, he then again said, please look at the CCTV footage. And they said, we will look at it. At no point did they look at the CCTV footage. And each of these investigations, disciplinary, the results were made within 1 hour. Hand-delivered letter. He lived about 20 minutes away from where the premises were, and they'd made the decision without doing a full investigation. Obviously, go to tribunal. Excuse me, this is many years ago. I represented, and actually he did win his tribunal. The fact is, this was a really sad case because it affected the person very badly, the conduct, etc. And this is what we've got. This is why we have to do a full investigation. We have to do it correctly. We have a responsibility in HR as employers, as managers, to do a full investigation, because it can impact dramatically on somebody's life. And without going into great detail, it did affect their life quite dramatically. So I want you to do this full investigation. It's there for a reason. However, if you're with me and you've been with me a short while, I really do want to go through a full investigation, disciplinary appeal procedures with you, because it's long-winded. And that is where we have on our CIPD HR Inform website a suitability clause. So you have a suitability clause which says within the probationary period, I reserve the right not to go through an investigation, disciplinary and appeal procedure with you. That's within the probationary period. I have that there to make it short, to make it short and snappy. To be fair, but I just want to go through a long-winded investigation, disciplinary and appeal with someone that's only been there for 5 minutes. I want to be able to make that decision quite quickly, and that's why a suitability clause is amazing. Careful you don't breach your own contract there. You must actually put a contract right within the probationary period that allows you to use a suitability clause. So that's available, again, as I said, on the CIPD HR Inform website. So let's follow in the ACAS code. The requirement for a disciplinary investigation is also set out in the ACAS Code of Practice on Disciplinary and Grievance Procedures. What does the code say? It is important to carry out necessary investigations of potential disciplinary matters without reasonable delay to establish the facts of the case. This can be damaging to somebody, the health-wise, with investigation. Let's not drag it out, okay? Let's do it without unreasonable delay. The statutory ACAS Code of Practice sets out the requirements for an investigation. And as you can see, the ACAS Code makes it very clear that the investigation is simply to find out the facts. It's fact-finding. It should not go any further than this. So, one of the key requirements for a fair dismissal is following a fair procedure. The investigation is the first step in a fair procedure. Unfair dismissal compensation is made up of the basic award. It's currently capped at $15,750, and the compensatory award currently capped at $86,444, or 52 weeks pay, which can then be increased up to 25%. So, following the ACAS code, an employment tribunal will consider whether the code has been followed when examining the fairness of a dismissal. An unreasonable failure to follow the code could lead to an increase of up to 25% in compensation awards. And remember, when you read in the paper, oh, somebody won £500,000 for unfair dismissal, that person, look at their job and what they do and what their wages are, you know. So just be careful and be very aware of somebody's, you know, job and what they do based on your wages. So again, an employment tribunal will consider whether the code has been followed when examining the fairness of a dismissal. An unreasonable failure to follow the code, as we said, could lead to that 25% increase. The ACAS code needs to be interpreted in line with internal procedures. So, for example, the ACAS code says carry out investigations without unreasonable delay. A policy may state that the investigation will be carried out within 7 days of receiving an allegation. So if you carry out the investigation within 10 days, this is likely to comply with the ACAS code, but will be a breach of your internal procedures, so breach of contract, written rules you've created. So if we're carrying out the investigation, what we need to look at is whether we're going to suspend the individual. So as I'm speaking to you, every single business listening to me today, I believe we have had over 600 people register for this. This is one of the hot topics that people always ask us about. This is where people use us to hold the hand, to write the letters, to get it right, to check that they're not breaching a contract. And this is where it's crucial when you take advice, of anybody, when you take that advice, you read out what you've got written down, because the advice you get must be conducive to what's written. If it isn't, you could end up with a breach of contract claim. Okay? We have the abolishment of tribunal fees. So these no-win, no-fee solicitors will be looking for some sort of breach. So what we need to remember is it a suspension? Is it relevant? So what might be gross misconduct or considered gross misconduct in one business might not be another. So make sure you never cut and paste from somebody else's contract. Make it sure it's relevant to you, okay? Suspension may be deemed necessary to carry out and ensure a fair investigation. So what are the risks to a fair investigation? What are the alternatives to limit these risks? And is suspension reasonable? And is there a proper cause? And remember, say, for example, I remember one particular case where two people had a fight in a factory. And rather than suspend both of the people concerned while they carried out an investigation, they suspended the person that they felt had always been the troublemaker. So be careful of who you suspend and make sure it is fair. And when looking at whether an individual will be suspended, ask yourself the following 3 questions that I've just asked you. So what are the risks to a fair investigation? What are the alternatives? And is suspension reasonable? And is there proper cause? So if we don't, what are the risks to a fair investigation? So examples include, it could be interfering with evidence. They could be hassling or pressurising witnesses. It could be placing the complainant in a vulnerable position. So you are only using suspension to enable a fair investigation to be carried out. So the first thing you need to look at is what risks would it be keeping the employee in work, have the fairness of the investigation. So ask yourself that, okay? So number 2, what are the alternatives to limit these risks? So the next step, once you've worked out what the risks are, is to check out whether you can take any other action to prevent this happening. So the risk is that the employee will access particular software and delete evidence, like clocking in, for example. Can you limit their access to the software? This would prevent the risk of the fairness of the investigation without having to suspend the employee. So examples include amending tasks, limiting access, and moving to a different department or location. So again, is suspension reasonable and is there proper cause? So if we look at the case with the London Borough of Lambeth, a Court of Appeal confirmed this will look at the manner of suspension, the events preceding the suspension. Is suspension a knee-jerk reaction? And do the facts of the allegation require suspension? Now, if you are using us, remember you can ring us for advice if you're looking at and you don't know whether to suspend somebody or not. So previous cases have confirmed that suspension should only be used in circumstances where it is reasonable and there is a proper cause. So it should not, let's remember this, be an automatic conclusion on receipt of an allegation of misconduct, even in cases of gross misconduct. So if we look at this case with Lambeth Council, and again, this full case is an HR inform, looking at factors will determine whether suspension is reasonable and there is proper cause will depend on actual circumstances of each case. If there isn't, a suspension could be a breach of the implied term of mutual trust and confidence, allowing the employee to resign and claim constructive unfair dismissal. So we need to make sure events proceed, whether alternatives have been examined, the reasonableness reviewed, whether the alleged perpetrator has been spoken to, and ensure all the initial consideration is noted and recorded as evidence. Let's not make it a knee-jerk reaction. Let's not just think because we feel that it's gross misconduct, they need a full investigation, a suspension. If you're unsure about this, again, don't hesitate to ring us for advice, because this is one area of employment law, the ACAS code, you have to get spot on. So you've got to get it right. That is why on our advice line, so many people, even HR experts, ring us just to double check that they're doing the right thing and to double check what they've got written down for gross misconduct and the reasons why. So again, failing to comply with the requirements of the code on suspension will be a breach of the ACAS code of practice. So as brief as possible, suspension should only be as long as required to allow the investigation to take place without interfering. And I'm sure the person sat at home would want a real quick conclusion on this, because they'll be worried sick about what's going to happen. It should not be overly long because of this. So keep it under review. Suspension can only be used when it is reasonable and there is proper cause, as mentioned before. So we spoke about that. Once the reasonableness and proper cause has gone, suspension is no longer needed and the employee should be returned to work. To know when this point is reached, the suspension should be proactively reviewed. So including the suspended employee in this process is important, so they are aware that these reviews are taking place. So keeping in touch with them. And again, there's a template letter available on HR Inform for anybody out there who doesn't, not everybody is great at writing letters, and that's why they use a resource such as that. So the letter to say we're reviewing it, and to take care that we're, to let you know that we're still reviewing it and what's going on. So suspension, again, let's recap, if no other alternatives available, but the code outlines that suspension should be as brief as possible, keep it under review, make it clear that suspension is not a disciplinary action. It is while we carry out the investigation, because we are a fair employer, we are fair HR, we are fair managers, we are carrying out a clear, precise, brief suspension. Okay, so when we do suspend somebody, we confirm it in writing. So it is important to set out the terms of suspension in writing, and this could be invaluable evidence if the matter is examined by an employment tribunal at a later stage. Remember, they go through your letters that you send with a fine-tooth comb, and then they look at what you've got in your handbook, what you have in your contracts. They will look at it and they will cross-reference to see if there is any breach. So make sure that you do get it spot on, okay? So the letter writing is crucial. Remember, I always say this on every webinar that I do, this is your defense. You are guilty until you prove yourself innocent, and this is how you prove yourself innocent. So confirm the suspension in writing, the reasons why suspension is necessary, the alternatives examined and why these aren't suitable, how suspension reviews will be carried out, any rules that apply during suspension, that this is not deemed a disciplinary action, and the next steps of the process. So carrying out the investigation. So what we have is carrying out the investigation. So who investigates? ACAS code says, where practicable, different people should carry out the investigation and disciplinary hearing. The investigating manager needs to be neutral, available, fully aware of the process and comfortable with asking appropriate questions. So who is picked out to carry out the investigation? It will have a significant impact on the later stages of the process, okay, and the fairness of the overall process. So when we say neutral, what we're actually saying is ensure the manager is not involved in the matter at all. When we say available, we're looking at, you don't want to pick someone who is tied up in ongoing matters or going on holiday. The investigating manager needs to be available to ensure the investigation is carried out in a timely manner. Okay, so when we say fully aware, you ideally want someone who has had training on carrying out an investigation or previous experience at least and knows how to do this properly. If not, using an experienced investigation manager could be the first step towards an unfair dismissal decision. Okay. When we say fully aware of the process, that again is, you know, we need somebody who is trained, you know. So interviewing. So when we say interviewing, they need to be comfortable at asking necessary probing questions where required and impartial, so no personal opinions are considered. Now, it can become apparent that some managers are not comfortable at conducting investigations, and this can become apparent when looking at the minutes and answers. These would be in front of an employment tribunal if challenged, and it's easy to pick where a manager is unbiased or does not understand what they're doing. So make sure you pick the right person. The employment tribunal will pick up on this. Okay. So, carrying out the investigation, what are you looking for? Okay, information support of the allegations, information goes against the allegations, i.e. support of the alleged perpetrator's version of events. This is the key part that many investigations fall down on. So as mentioned previously, the investigation is the fact-finding stage. So trying to gather all the facts about the incident or allegation, etc. So what we need to do is discover all the facts. The investigating manager needs to look at all the information in support of the allegations and any that goes against the allegations as well. So we're looking at both sides here. Doing just one, so only gathering information in support of the allegations, will be unfair and unreasonable investigation. And it's so easy to do that when you're hearing other managers talking to you and saying, yes, they did it, they definitely did. You know, let's look unbiased, give somebody a fair investigation. If we look at it one-sided, the investigating manager is not even considering the idea that there may be another version of events. So they're not looking at witnesses. There might be other witnesses and evidence that supports this. Instead, they're only focusing on the complainant's version and failing to consider anything else. Taking one person's word against the other is not the role of the investigating manager. Let's remember that. So we need to record this investigation process. We need to document everything. You know that. I've got HR experts listen to me. I've got people who've never done an investigation before. We need to document it. This is going to be used as evidence. So the investigating manager will be keeping a record and clear notes as to the actions they have taken in the course of the investigation. These notes should also include records of why the investigator manager, you, has taken particular decisions. So if I say, for example, the investigating manager chooses to interview somebody not initially identified, or if they choose not to explore, excuse me, a suggested piece of evidence, they may need in the future to explain why they took that decision. And when you're at a tribunal being questioned, you might forget why you did. So that's why it's absolutely crucial to take notes of why you made that decision. The test here will always be the one of reasonableness. Let's remember that word, reasonableness. If an investigation manager is unable to explain why they took a particular decision, it may compromise the legitimacy of the entire investigation and leave them open to allegations of bias. And they might be really fair, they might be unbiased, but they haven't made a note. And it can, again, even for the investigating manager, will knock them for 6 and make them feel bad. So we need to keep a record. So if I want to interview somebody that probably isn't on the list, I need to put a reason down as to why I have. If I want to look at CCTV that nobody suggested, I need to put a note next to it to say why I do that. Okay, so remember, the form is available again on HR Inform to record, why there's notes for you. Carrying out the investigation, hold the investigation meeting. It's a meeting to find out the alleged perpetrator's account of events. Ensure the meeting is minuted properly. These will be important information for the remainder of the process, and no statutory right here to be accompanied. But double check your internal procedures. Remember, the advice you take must be conducive to what you have got written down. So if you're saying in your handbook, yes, you can have a witness whenever you want, remember, don't breach that, okay? A common error that people make. So when you're holding the investigation meeting, questions need to be to explore allegations and any evidence refuting these. You're asking biased questions that only focus on the complainant's version of events will result in an unfair investigation. Ask open questions, encouraging the alleged perpetrator to provide as much information as possible. So here, we're holding an investigation meeting. So what we're doing is we're looking at asking questions relating to admittance or denial of events, knowledge of rules, alternative version of events, dates and times of alleged incidents, witnesses, available evidence as well. So that's what you're looking for when you're holding the investigation meeting. And what we're doing is we're gathering that additional evidence and witness statements, which may be taken from any witness aimed at supporting or refuting the allegations. Invite to a meeting and ask for as much information as possible of their version of events. People may want to be anonymous, but that's going to be difficult to promise. Where a witness is involved in a particular incident as well. So essentially, anyone named by either the complainant or the alleged perpetrator should be spoken to. It may take time to do this. Missing out one person could lead to a failure to gather all the relevant information that you need. This person may be, if you think about it, the most important witness. But how do you know this if you haven't spoken to them? So when gathering other information, you may also identify other witnesses that need speaking to. This may be, for example, the person who received the original complaint, the person with knowledge of certain software or technology, for example. So again, we're gathering additional evidence. We'll include gathering copy of internal rules, policies, procedures, CCTV or surveillance evidence, formal records, in sheets, for example, absence records, previous disciplinary records, witness statements, and notes of meeting, including investigation meeting. So that's sort of the additional evidence that you will be gathering. So what happens where there is conflicting information? I'd consider re-interviewing the complainant, the alleged perpetrator, witnesses, and others involved in the early process, for example, the individual who received the complaint. So what you will need to consider and question, I would say, is to consider the context, the motives, and potential bias of any witnesses. When people have friends at work, managers like certain people, remember that when you're carrying out this fair investigation. So what happens when there is conflicting information? So what I would suggest is carry out further checks to confirm the details are consistent, the names, the dates, the times, etc. And it will only really give you the opportunity at this stage, I think, that you can probably determine that the stories don't match up. And one version of events should be supported by unbiased, uninfluenced evidence. So example, CCTV, computer records, emails, messages, etc. So make sure the details are consistent, names, dates, times, evidence gathered, backup statements, the internal investigation procedures have been followed properly and consistently. So that what we're going to get to now is the final part of the investigation, and that really is, again, this is a really, really important part. So the investigation report will potentially be submitted to the disciplinary panel, a chair, and will be that which is relied on really at later stages and the decision. So if you've done all the earlier work completely, fairly and reasonably, but muck it up at this stage, all that hard work will be effectively wasted. So what a waste of time. So we need to create a report that needs to contain all the information, evidence that is factual, unbiased, relevant, supports the employee, and so goes against the employee. So we need to get proper evidence here, and we need to not muck it up at this stage. So when we create the report, depending on the type of allegation, the amount of information gathered, what we have is details of the allegations, including who, what, where, when, and how, notes of the investigation meeting and witness statements, other relevant information or data, summary of findings, and whether on balance of probability there is a case to answer or not. So that's what we're going to do in the report. And if people go, gosh, it's long-winded, isn't it? What am I there? We've got all this going on. It's there for a reason. It's going to cost you a lot of money if you end up in a tribunal because you've got it wrong. And it doesn't matter what size of business you are, the awards are exactly the same. So remember that when you sat there and you've got 3 staff and there's only you as the employer, that this is going to be costly if you get it wrong. So you've got to get it right. So concluding the investigation, where it is concluded that there is a case to answer, the investigation report will be submitted to the disciplining manager. The investigation manager should take no further part except providing evidence or answering further questions about the investigation process. So the risks of a bad investigation: fail to gather all the relevant information in support of and against the employee. This is likely to lead to an unfair dismissal because this is the information, as I've said all along, that is relied on in the later stages of the disciplinary process. So, for example, disciplinary decision based on insufficient investigation report will be unfair, not reasonable. Number 2, does not meet the requirement to be reasonable in all the circumstances. So reasonableness will impose a higher test in cases concerning professional and qualified individuals. So the Court of Appeal in the Salford NHS Trust versus Roland, the more serious the potential consequences of the dismissal, the more thorough the investigation should be. So reasonableness always depends on the circumstances of the case. If the disciplinary process could potentially end the career of a professional or lead to criminal charges, deportation, etc., the test of reasonableness will be much higher. This was set out by the Court of Appeal in the Roland case. An automatic suspension without considering alternatives will be a breach of the implied term of mutual trust and confidence. And this entitles the employee to resign and claim constructive unfair dismissal. So again, number 3 is suspension is unreasonable and there is no proper cause. So this really will affect somebody. Why did they suspend me? This just means they don't trust me. It wasn't worth suspending me over, but they put me on full pay, suspended me, made me feel I was guilty straight away, and yet it was only a minor incident. And I've had enough now. I'm going to resign and claim constructive dismissal or constructive unfair dismissal. So let's get it right. There's 76 complaints in tribunal by everybody. The 2 most common, unfair, constructive. You've heard me talk about. There's lots of other reasons. So when we suspend somebody, I'm sure there's a reasonable cause for this. And automatic suspension following alleged or misconduct can reach the implied term of mutual trust and confidence. So number 4, the investigation is influenced or biased. This is likely to lead to an unfair dismissal because the eventual outcome will be influenced. Dismissal in the case for Rampal versus Department for Transport. Dismissal was unfair because HR persuaded the investigating manager to take a more critical view of the conduct. So what we're looking at here, when I'm bringing these cases as an example, that are available for you to read in depth on HR Inform, is if you look, they're large, huge companies that have a bespoke HR department. That tells me that even brilliant HR experts can get it wrong. So let's get it right. This is where, if you're ever worried about getting it wrong, or you're unsure what you're doing, as to what you're doing, I want you to use our resources. Have a look at what we do. You might be surprised at how we can help you. So HR Inform resources. We've got on our website employment law resource on disciplinary procedures and how-to guide on designing and managing HR investigations, a flowchart on carrying out an investigation into gross misconduct, letter inviting an employee to an investigatory meeting, letter to send. Look, I'm not going to read them all out. You know, I was going to, but then I got to half and thought, what's the point in that? But let's remember, it's really hard to dismiss somebody for something that's not written down. So we need to make sure that we have got in our gross misconduct, we have rules and procedures, general rules, but this list is not exhaustive. And then we have a gross misconduct. A list of the following acts are examples of gross misconduct offences and as such may render you liable to summary dismissal. So the list is not exhaustive. So it's like fighting, physical assault or dangerous horseplay. Dangerous horseplay, how old-fashioned does that sound? Deliberate refusal or willful failure to carry out a reasonable, lawful, direct instruction given by management during working hours. My daughter works in a manufacturing company as a PA in HR over in North Wales. As you know, I'm based in North Wales. And she said, Mum, you're not going to believe this. The other day we had visitors on site and they're really strict on health and safety. And one of the subcontractors came in to repair a machine and they have to wear nets in the hair, hats, visual high-vis jackets and safety boots. And she said she gave him the safety boots and he hid them and wore trainers and he was escorted off the premises. You know, that is, and that was a subcontractor, but an employee doing that would be, you know, as far as I'm concerned, gross misconduct again, following instruction. It's amazing things people do. I hope one day you get the chance to attend one of our CIPD HR Reform seminars where you get to meet me. We have lunch and we talk for 3 hours on an overview of everything. What I would suggest to you, if anybody would like to attend one of our seminars, to email events@hr-inform.co.uk. Also, when we do these webinars, because we always seem to get out of time, I don't have a chance to answer all the questions because I'm going to have to read the list live and it'll take me ages. What I would ask you to do is, if you have a question, we will get to them off the webinar, but I would like you to email me that at events@hr-inform.co.uk. Also, you've heard me mention the CIPD HR Inform. I can't sit here and see how many clients we've got, that because, you know, I'd be here all day, and how many people we support. But also, we have been around for over 75 years, so just bear that in mind. We're not new kids on the block. So if you would like to know about our CIPD HR Inform and get a free 24-hour trial, and have a look at all those documents, go-to guides and case history, which are great for your qualifications, etc., and learning, ongoing learning, great for anybody in HR or managing staff. Get in contact with us. We will you anyway. I'd like to hope you enjoyed my webinar today. My name is Chadwick. I'm a speaker. I'm a writer, and I hope that you enjoyed our session. I'd love to speak to you again soon, and it's goodbye from me. Thank you very much for listening.